Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today.
So today on the podcast, we have one of my absolute favorite 1L torts cases, Mustapha and Culligan. This case, I think, sticks out in the minds of the majority of law students in Canada. I know I've seen on Facebook the meme ones about the ginger beer and the snail. Yeah, we get it. But Mustapha and Culligan is uniquely Canadian.
Definitely.
And such an interesting read for being such a short case. It's only about 20 paragraphs long, and the Chief Justice is so succinct with her articulation of the test of negligence and why in this case the threshold isn't met.
Yeah. It is a masterclass in like succinct, to the point decisions. Like, you aspire to be this level of like, here is the point, watch me make it, thank you, have a good day. It is truly amazing. And yet, for the record, Donahue and Stevenson is much harder to read because I've been trying to record it for a month and I keep getting bored and leaving it. So Mustapha and Culligan is truly the best. I actually read it weirdly. I read it like my second week of law school because we did it in legal research and writing. They had us read it to practice case briefing because it's so short that they're like, this is perfect, read it, make your headings, find what works for you. So yeah, I read this like right away, and I had the terribly untrue assumption after reading it that all cases were this succinct and well written, and I was like, this is gonna be great. Like, what are people talking about reading these decisions?
Why is law school hard?
Yeah, like what? Like, it's hard? Like, it's like, this is great. But yeah, it was a very rude awakening when I found out not every case is Mustapha and Culligan, but it's the best. Plus, like, gotta shout out Windsor at all opportunities.
Yeah, absolutely. And it's one of those cases that I think it's important that, everybody reads, because again, it's only 20 paragraphs long, so it's really short and it's really succinct. And I think a lot of the times, especially when it comes to legal research and writing, we often don't know what to say, especially as students. We don't know how to articulate our points. And I think reading like a short, succinct case like this that makes excellent use of like subheadings and headings.
Oh, yeah.
And very like succinct, like, here is the state of the law from this case. Here's why it applies or does not apply based on the facts. And I think that is an excellent case for everyone to learn. Oh,
yeah, definitely. And especially, I feel like all law students in Canada go through this, but eventually, like, you end up with such deep appreciation when they use subheadings appropriately, because you're just like, oh, thank God. Like, I can follow what's happening. I know where I am. I can keep track. Because sometimes when you go through these older decisions and it's like, oh, good, a 20,000 word block quote. This is going to be terrible. Like, it's just the ideas of accessibility and ease of reading. Like, these are actual access to justice, public access issues. And it's so nice when higher levels of court are just like, we're going to write things in a way that people can understand them, because that's important.
Yeah, especially when you consider like what common law is common law just like exists in an ether effectively. Like, it's written down and it's published, and you can access the Supreme Court of Canada decisions through Canly or their own website. But like, individuals ought to know the common law, but sometimes it's not easy to read, a 200 paragraph decision like in America, for example, where they discuss the nuances of like search and seizure.
Yep.
Sometimes when most people interact with the law, especially in tort, sometimes shorter and more succinct is just better.
Oh,
and it's easier for the public. It's way easier for counsel.
Yep.
It's a constellation of really good things in one tightly packed, funny little case.
No, exactly. And yeah, as I say, even from like a disability accessibility perspective, it is literally just better when things are written at a level where they are understandable, right? Like, and as I say, if you can't explain something succinctly, I don't really think you understand it that well. And so it's like a lot of the times there's these, like endlessly long-winded decisions excuse me, that, they're hard to read and you don't really know what's going on. And you're just like, dude, do they even know what this is? Because, like, if you can't articulate it, it's like, well, how well do you really understand it, right? Whereas I find actually writing in a succinct way is such a skill because it shows like an absolute mastery over the subject matter.
Definitely. And I think the other interesting thing about this case is I think it really represents a good case of like client advocacy, right? I don't doubt Mr. Mustapha's claims in the least,
No.
but the difference is, you understand and you empathize with your client's point of view, but you also have to understand, what is the state of the law and how can it apply in the case? And I think this case demonstrates that very well.
Yeah, definitely.
So I hope everybody enjoys. It's a very short one. The reading won't be that long, but enjoy Mustapha and Culligan. Mustapha and Culligan, heard on the 22nd of May in 2008. Writing for a unanimous court, the Chief Justice, Beverly McLachlin. The plaintiff, Mr. Mustapha, sues for psychiatric injuries sustained as a result of seeing the dead flies in a bottle of water supplied by the defendant, Culligan. In the course of replacing an empty bottle of drinking water with a full one, Mr. Mustapha saw a dead fly and part of another dead fly in the unopened replacement bottle. He became obsessed with the event and its revolting implications for the health of his family, which had begun consuming water supplied by Culligan for the previous 15 years. The plaintiff developed a major depressive disorder with associated phobia and anxiety. He sued Culligan for damages. The trial judge found that seeing the flies in the water resulted in psychiatric injuries to Mr. Mustapha and awarded him $80,000 in general damages, $24,174.58 in special damages, and $237,600 in damages for the loss of business. The Ontario Court of Appeal overturned the judgment on the basis that the injury was not reasonably foreseeable and hence did not give rise to a cause of action. The issue before the court is whether the cause of action has been established. For different reasons than the Court of Appeal, I conclude that it has not. A successful action in negligence requires that the plaintiff demonstrate 1. That the defendant owed him a duty of care, 2. That the defendant's behavior breached the standard of care, 3. That the plaintiff sustained damage, and 4. That the damage was caused, in fact and in law, by the defendant's breach. I shall examine each of these elements of negligence in turn. As I will explain, Mr. Mustapha's claim fails because he has failed to establish that his damage was caused in law by the defendant's negligence. In other words, his damage is too remote to allow for recovery. 1. Did the defendant owe the plaintiff a duty of care? The first question to consider in an action for negligence is whether the defendant owed the plaintiff a duty of care. The question focuses on the relationship between the parties. It asks whether this relationship is so close that the one may reasonably be said to owe the other a duty of care to not injure the other. See Donahue and Stevenson. Whether such a relationship exists depends on foreseeability, moderated by policy concerns. See Ann's and Merton London Borough Council. In many cases, the relationship between the plaintiff and the defendant is a type which has already been judicially recognized as giving a rise to a duty of care. In such cases, precedent determines the question of duty of care, and it is unnecessary to undertake a full-fledged duty of care analysis. As stated by A. M. Linden and B. Feldson, categories of relationships that have been recognized and relationships analogous to such pre-established categories need not be tested by the ANDS formula. See Canadian Tort Law 8th edition and Cooper and Hobart. The relationship between the parties in this case does not belong to a novel category. It has long been established that the manufacturer of a consumable good owes a duty of care to the ultimate consumer of that good. See Donahue and Stevenson. It follows that Culligan owed Mr. Mustapha a duty of care in supplying bottled water to him. 2. Did the defendant's behavior breach the standard of care? The second question in a negligence action is whether the defendant's behavior breached the standard of care. A defendant's conduct is negligent if it creates an unreasonable risk of harm. The trial judge found that the defendant, Culligan, breached the standard of care by providing the plaintiff with contaminated water, and the parties did not appeal that finding before this court. This is hardly surprising. it is clear that a supplier of bottled water intended for personal consumption is under a duty to take reasonable care to ensure that the water is not contaminated by foreign elements. The second element of liability in tort for negligence is therefore met. 3. Did the plaintiff sustain damage? Generally, a plaintiff who suffers a personal injury will be found to have suffered damage. Damage for purposes of this injury includes psychological injury. The distinction between physical and mental injury is elusive and arguably artificial in the context of tort. As Lord Lloyd said in Page and Smith, in an age when medical knowledge is expanding fast, and psychiatric knowledge with it, it would not be sensible to commit the law to a distinction between the physical and psychiatric injury, which may already seem somewhat artificial, and may be soon altogether outmoded. Nothing will be gained by treating them as different kinds of personal injury as to require the application of different tests in law. This said, psychological disturbance that rises to the level of personal injury must be distinguished from psychological upset. Personal injury at law connotes serious trauma or illness. See Hinds and Berry, Page and Smith, Linden Feldson. The law does not recognize upset, disgust, anxiety, agitation, or other mental states that fall short of injury. I would not purport to define compensable injury exhaustively, except to say that it must be serious and prolonged and rise above the ordinary annoyances, anxieties, and fears that people living in a society routinely, if sometimes reluctantly, accept. The need to accept such upsets rather than seek redress in tort is what I take the Court of Appeal to be expressing in its quote from Vanek and Great Alliance in Pacific Cove, Canada. In quotations, life goes on. Quite simply, minor and transient upsets do not constitute personal injury and hence do not amount to damage. On the findings of the trial judge, supported by medical evidence, Mr. Mustapha developed a major depressive disorder with associated phobia and anxiety. This psychiatric illness was debilitating and had a significant impact on his life. It qualifies as a personal injury at law. It follows that Mr. Mustapha has established that he sustained damage. 4. Was the plaintiff's damage caused by the defendant's breach? The fourth and final question to address in a negligence claim is whether the defendant's breach caused the plaintiff's harm in fact and in law. The evidence before the trial judge established that the defendant's breach of its duty of care in fact caused Mr. Mustapha's psychiatric injury. We are not asked to revisit this conclusion. The remaining question is whether that breach also caused the plaintiff damage in law or whether it is too remote to warrant recovery. The remoteness inquiry asks whether the harm is too unrelated to the wrongful conduct to hold the defendant fairly liable. See Wagon Mound No. 1. Since the Wagon Mound No. 1, the principle has been that it is the foresight of the reasonable man which alone can determine responsibility. See Overseas Tank Ship, United Kingdom Limited, and Mort Stock and Engineering Co. Much has been written on how probable or likely a harm needs to be in order to be considered reasonably foreseeable. The parties raise the question of whether a reasonably foreseeable harm is one whose occurrence is probable or merely possible. In my view, those terms are misleading. Any harm which has actually occurred is possible, and it is therefore clear that the possibility alone does not provide a meaningful standard for the application of reasonable foreseeability. The degree of probability that would satisfy the reasonable foreseeability requirement was described in the Wagon Mound No. 2 as a real risk, i.e., one which would occur to the mind of a reasonable man in the position of the defendant, and which he would not brush aside as far-fetched. See Overseas Tank Ship United Kingdom and Miller Steamship Co. Party. The remoteness inquiry depends not only upon the degree of probability required to meet the reasonable foreseeability requirement, but also upon whether or not the plaintiff is considered objectively or subjectively. One of the questions that arose in this case is whether, in judging whether the personal injury was foreseeable, one looks at a person of ordinary fortitude or at a particular plaintiff with his or her particular vulnerabilities. This question may be acute in claims for mental injury, since there is a wide variation in how particular people respond to a particular stressor. The law has consistently held, albeit within the duty of care analysis, that the question is what a person of ordinary fortitude would suffer. See White and Chief Constable of South Yorkshire Police, Devji and Burnaby District. Vanek. As stated in White, The law expects reasonable fortitude and robustness of its citizens and will not impose liability for the exceptional frailty of certain individuals. As the Court of Appeal found at para 49, the requirement that a mental injury would occur in a person of ordinary fortitude, as cited in Vanek at paras 59 to 61, is inherent in the notion of foreseeability. This is true whether one considers foreseeability at the remoteness or at the duty of care stage. As stated in Tame and New South Wales, per Gleason, CJ, this is a way of expressing the idea that there are some people with such a degree of susceptibility to psychiatric harm that it is ordinarily unreasonable to require strangers to have in the contemplation the possibility of harm to them, or to expect strangers to take care to avoid such harm. To put it another way, unusual or extreme reactions to events caused by negligence are imaginable, but not reasonably foreseeable. To say this is not to marginalize or penalize those particularly vulnerable to mental injury. It is merely to confirm that the law of tort imposes an obligation to compensate for any harm done on the basis of reasonable foreseeability, not as insurance. The law of negligence seeks to impose a result that is fair to both plaintiffs and defendants, and that is socially useful. In this quest, it draws the line for compensability of damage, not at perfection, but at reasonable foreseeability. Once a plaintiff establishes the foreseeability that a mental injury would occur in a person of ordinary fortitude, by contrast, the defendant must take the plaintiff as it finds him for the purposes of damages. As stated in White at 1512, focusing on the person of ordinary fortitude for the purposes of determining foreseeability is not to be confused with the eggshell skull situation, where as a result of a breach of duty the damage inflicted proves to be more serious than expected. Rather, it is a threshold test for establishing compensability of damage at law. I add this, in those cases where it is proved that the defendant had actual knowledge of the plaintiff's particular sensibilities, the ordinary fortitude requirement need not be applied strictly. If the evidence demonstrates that the defendant knew that the plaintiff was of less than ordinary fortitude, the plaintiff's injuries may have been reasonably foreseeable to the defendant. In this case, however, there was no evidence to support a finding that Culligan knew of Mr. Mufasa's particular sensibilities. It follows that in order to show that the damage suffered is not too remote to be viewed as legally caused by Culligan's negligence, Mr. Mustapha must show that it was foreseeable that a person of ordinary fortitude would suffer serious injury from seeing the flies in the bottle of water he was about to install. This he failed to do. The only evidence was about his own reactions, which were described by medical experts as highly unusual and very individual. There is no evidence that a person of ordinary fortitude would have suffered injury from seeing the flies in the bottle. Indeed, the expert witnesses were not asked this question. Instead of asking whether it was foreseeable that the defendant's conduct would have injured a person of ordinary fortitude, the trial judge applied a subjective standard, taking into account Mr. Mustapha's previous history and particular circumstances, including a number of cultural factors, such as his unusual concern over cleanliness and the health and well-being of his family. This was an error. Mr. Mustapha having failed to establish that it was reasonably foreseeable that a person of ordinary fortitude would have suffered personal injuries, it follows that his claim must fail. 5. The claim in contract. The plaintiff also brought a claim for damages arising out of breach of contract, although he appears not to have pursued it with vigor. This claim fails. With regard to Mr. Mustapha's psychiatric injury, there is no inconsistency in principle or in outcome between negligence law and contract law. Damages arising out of breach of contract are governed by the expectation of the parties at the time the contract was made. See Hadley and Baxendale. Damages arising out of a breach of contract are governed by the expectation of the parties at the time the contract was made, as distinguished from the time of the tort in the case of tort. I have concluded that personal injury to Mr. Mustapha was not reasonably foreseeable by the defendants at the time of the alleged tort. The same evidence suggests that Mr. Mustapha's damage could not be reasonably supposed to have been within the contemplation of the parties when they entered their agreement. 6. Conclusion. For the reasons discussed, I conclude that the loss suffered by the plaintiff, Mr. Mustapha, was too remote to be reasonably foreseeable, and that consequently he cannot recover damages from the defendant. I would dismiss the appeal with costs. In the light of these findings, I find it unnecessary to deal with the cross appeal and dismiss it without costs.
Legal Listening is founded by Zach Battiston and Carly Lyons. Hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radamile. Audio engineering by Anthony Radamile. Graphic design by Julie Lundy at julielundyart.com. Music by Matt Radamile at radandkel.com. We're always open to ideas, suggestions, and of course, guest readers. Check us out at Legal Listening on Twitter and at legallistening.com. We'll talk to you next time.